Welcome to the Small Business Contracts Coach.
Welcome to the Small Business Contracts Coach with attorney Darryl Shaper of the fixed fee law firm PLLC. Darryl brings 30 years of business and legal experience helping Texas entrepreneurs get protective, plain English contracts at fair and predictable prices. I'm Leanne Lyon, and today we are talking about the key legal documents every small business actually needs and why they matter. Hello, Darryl.
Hey, Leanne. Great to see you.
Great to see you. And Darryl, before we get to the documents themselves, why don't you tell us a little bit about your background? How did you go from big law firm to building a fixed fee practice for small business owners?
It's quite the journey I've had. I've had an interesting life. I'm blessed by that. But I actually have been more a business person than I've been a lawyer. So I went to law school. I practiced at Texas's largest firm for 2 years, and I absolutely hated it. So I was a miserable corporate attorney. I thought we charged too much and didn't add enough value. So I went into technology for about 20, 30 years, and I built several companies along the way. And one of the things that frustrated me most when I was building companies of my own is lawyers. They were too expensive, they were slow, the pricing was unpredictable. So I built a law firm that is the kind of law firm I'd have wanted when I was a small business and an entrepreneur, with fixed fees, predictable pricing, fast, fair legal review of your contracts. And so basically over the last several years, we've built the firm and it's grown really fast, and people seem to like the product that we offer.
Oh, wonderful. And so you are specializing in entrepreneurs. And when you meet a new entrepreneur in Texas, what are the first few documents that you look for to see if they're set up correctly?
Yeah, one of the very, very first things that I talk to people about is forming a limited liability company. We'll talk more in future episodes about LLCs, but almost always a limited liability company is a great idea for the entrepreneur, in that when you form that limited liability company, and it's quite easy to do, you protect your personal assets from any kind of lawsuit or liability that might get imposed upon that new business. So, there is liability just in the real world. There are things that could go wrong. And so, this limited liability company, as long as you handle it appropriately, and again, we'll talk more about that in future episodes, it protects your home, your personal assets from being taken in the case of a significant lawsuit.
Excellent. And I'm just going to throw one in here. Is that something that you find some entrepreneurs just don't know they need to do?
It is. It's one thing that they sometimes don't know they need to do it. Many of them know. Um, and I and but many of them get confused and wrapped around the complexity of figuring out which state they ought to form their LLC in. And it's really quite simple. Wherever you're doing business, that's probably the state where you ought to form your business. And it's also really quite simple in that there are multiple types of businesses, but an LLC is almost always the better answer than a C corporation, which has 2 levels of taxation. So I always recommend an LLC for an early stage company.
So beyond the LLC, how do you help clients decide which contracts they need right away versus what can wait until they grow a little bit more?
One of the other sort of thing or key things that I recommend in general in the first year or so of a startup company is be very careful and thoughtful about hiring actual employees. So
Mhm.
there's independent contractor agreements, you've probably heard of that, or 1099 employees instead of actual employees. And in the early days of a company, I almost always recommend you hire people as an independent contractor rather than as an employee. You can do a try before you buy with an independent contractor. It's much easier to terminate an independent contractor than it is to terminate an employee. the tax filing complexity associated with employees and the various taxes you need to pay on their behalf can get complicated. You're going to need a payroll system once you've got employees. So, my recommendation is early on, start with independent contractor agreements rather than actually hiring people as employees. So, that's tip number one. Tip number two and document number two, I would say that's really, really important is depending upon what your business is and what you're providing, either a service or a product, you want to have good, solid contracts that govern your relationship with your customers. Some of the key things there are a limitation of liability, careful indemnification, which is a complicated topic we can get into in another day. But those are some of the key things that you want to get into your services contract so that you're not overly exposed to liability there. And then the last thing that I would say that we work on a lot is almost every business gets its business through digital marketing today. So you're going to have a website, right? And on that website, you need some of the basic elements of terms and conditions for your website, a privacy policy, a cookie policy. And there's some great tools that we use in my firm that make that relatively easy and relatively inexpensive to get a protective set of documents governing your website and protecting you on your website.
Excellent. So those are the core documents to get right away. Are there other ones that they can get later?
Yeah, of course. Each situation's different, right? And then often, depending upon if you're in business to business, the other side is going to either create the counterparty may create the first draft of the document. So my firm helps people review those documents that come from the counterparty to make them more fair and balanced
Yeah.
for my client. That's often something that happens. You may decide, hey, I do need to bring on employees at this point. Now you may want to have an employment agreement. I do a lot of operating agreements. So back to the formation of the LLC, when you form that LLC, the governing document is called an operating agreement. And that document can be pretty complicated and can be very, very important in that it sets up the governance of the organization. But there are non-disclosure agreements. It's funny, today I probably have worked on 3 non-disclosure agreements. I don't actually work on them super often, but they're simple. It's the most commonly signed document or contract in the United States of America. And they're really pretty easy, but I recommend you get a lawyer to review them. I review them for $149 fixed fee, very inexpensive. But often the counterparty will slip in something like a non-solicit, a non-compete, or even a sort of a non-circumvention provision into that non-disclosure agreement. And you don't want to sign those. It's too early on in the relationship when you're signing a non-disclosure to agree to some of these things that people may try to slip in and that you may not understand what you're signing.
Wow, that sounds like a good reason to reach out to a great lawyer.
Yeah, in general, again, that's why I try to do it inexpensively and fast, is that for my good clients, like one of my good clients shot me his NDA today and said, "Is there anything you're worried about here?" And I quickly reviewed it and shot him back a note with 3 or 4 points that I thought were unusual in that non-disclosure agreement. But I said, sign it as is, because in general, showing that you're easy to do business with and fast at that non-disclosure stage is really a good sign that's going to help you win business with the counterparty. If you're relatively easy to do business with early on, and then when you get to the more complicated documents, it becomes more important. And then additionally, one final point on non-disclosures is even though tons and tons of them get signed, they're very rarely litigated because it's very difficult to prove the disclosure of confidential information. So I don't worry about them excessively because they're so infrequently litigated.
Oh, Good points, all of them. Really, I would hesitate to push back on a non-disclosure, and even not having heard what you said, but excellent points on all fronts
Yeah,
there.
that's right, right? In our day-to-day business, people just wanna it's almost more of a reminder, "Hey, I'm gonna tell you stuff that's confidential. Don't go disclosing that." And so being really difficult and marking the heck out of that just makes you look like you're a difficult counterparty.
For sure. So if a company uses, we talked about contractors, if a company uses contractors or freelancers, what should be spelled out in those agreements to avoid misclassification issues?
Great. Interesting question. So the misclassification element of it is, again, in my view, not that hugely important for small businesses. The key issue here is you cannot excessively control and guide the day-to-day activities of the person. So the courts look at things like, did I tell them exactly what time to show up? Did I provide them with a computer or did they use their own computer? They need to be more independent, more autonomous in how they get the work done. Realistically, though, small businesses aren't going to often get a contractor reassigned as an employee. So, because it's really big companies like Microsoft that used many, many contractors and sort of didn't want to give their benefits to their employees that got busted for the
Yeah.
reclassification. More important in your intellectual independent contractor agreement is the treatment of the intellectual property that that independent contractor may create for you. So the two key provisions that I try to get in is absolute complete clarity that the work product that's being developed by the independent contractor is owned by my client, the company, the person that those services and that work product's getting created for, because you don't want to have any issues where there's a concern about whether you own that work product. Obviously, confidentiality is important. You might put a non-compete or a non-solicit into an independent contractor agreement. But the second thing that's the super important thing that I always recommend is easy termination for
Mhm.
convenience.
Yeah.
Because when you hire this contractor, you want to be able to get out of the contract quickly and easily if they're not working out. So a very short, not even 30 days, like, hey, in 7 days or 5 days, if I'm not satisfied for any reason, I can terminate this independent contractor agreement.
Yeah, I try to remind myself, these are people, they have a life, and they're eventually probably are going to leave, or I may want them to. And just, acknowledging that humanity between all of us, but the contracts make it a little easier for sure. Let's talk about money. Where do business owners most often get into trouble with payment terms? Things like deposits, late fees, or refund policies.
I haven't thought about that question a ton. I would say the biggest thing there is the payment terms itself, right? It's relatively standard in business today to have net 30.
Mhm.
Fascinatingly, the bigger the customer is on the other side from my small business, the worse the payment terms are. If you're dealing with Exxon or some giant corporation, they want 60, 90-day payment terms, right? I always tell my small business clients, push back hard on that. There is no reason for you to be loaning Exxon or some other Fortune 500 company money. You're the little guy here without the cash assets. Do not let them bully you into taking 60 or 90-day payment terms. That's absurd. So that's one of the biggest areas of concern. Interestingly, right, many contracts have late payment terms in them. But again, pragmatically, right? I like to say I'm a more pragmatic than your average lawyer. How often do you actually charge 1.5% interest per month on late payments? It's almost never. And it really will irritate the other side if you do that. So just get net 30 payment terms. Don't give any kind of prepayment discount. Those are the two sort of big gotchas that I see on payment terms.
So how about what are the core pieces of a solid contract service agreement that keeps scope and payment clear from day one?
That's such a great question. So I always tell clients again, when you do a contract, often there's a master services agreement that's your sort of contract if you're going to do a series of ongoing projects. And then attached to that master services agreement is a statement of work that explains the details of the work to be done, the deliverables that are going to be delivered, the timelines, etc. And the key area to focus on in those documents is the statement of work. You don't want to provide adjectives or loose language in the statement of work. So I don't want to say to you, I'm going to provide thorough and excellent legal services. That's a really bad idea. What the heck does thorough and excellent legal services mean, right? These adjectives create a degree of uncertainty. And typically, what's going to happen is the client doesn't want to pay. For some reason, they don't want to pay. Well, they're going to look at that statement of work and they're going to say, hey, Darryl, your services weren't thorough and they weren't excellent. And so I'm not paying. Right. So you don't want to put loose language like that into the statement of the work. You just want to say, I'm going to review this non-disclosure agreement for you, provide a set of comments, and have a call with you for up to 30 minutes. That's what I'm doing for $149, nothing more. And you can't say that you don't owe me the $149.
So what I'm hearing is that you are a lawyer who is not in love with loose language. How cool is that?
How cool. Every lawyer. Although I don't know if you've learned this in talking to lawyers, but they love to say it depends as the answer to all kinds of questions, right? I try to avoid that. I try not to answer the question. It depends. It does sometimes depend, but it's just such a classic lawyer answer. I don't like to give it.
Cool. Well, we're about to wrap up here, but before we do, can you share just a quick example of a client who saved time or money by getting their key documents in place early instead of waiting for a problem to happen?
I can share exactly the opposite, if that's okay. If I can turn the question
Sure.
around. I
Sure.
had a client the other day who worked with a guy who was doing certain services for him, and he kinda knew the guy, and he just did it on a verbal. "Hey, you're an independent contractor. We're just gonna do this. I'll pay you, you know, $500 a week, and you're just gonna do a couple hours helping my guys answering a few questions." Well, turns out about a year later, he decides to get rid of the guy, and the guy claims that he was an employee, claims that
Mhm.
he's due unemployment, and ultimately, my client has to settle with this guy for a non-trivial amount of money because he had nothing in writing. He had done verbal. So it's very, very important to document the relationship, the independent contractor relationship, or that can come back around and bite you in the end if you think that verbal agreement is going to be um, fine, or a verbal agreement's not enforceable. Well, in reality, in some states, a verbal agreement is enforceable, number one. And number two, there was a track record of him paying over a year. And so it was difficult for him to say, hey, no, you were just an independent contractor. So he had to settle.
Wow. Well, thank you. That's a wrap for our episode today of the Small Business Contracts Coach. To work with Darryl and learn more about fixed fee contract services for entrepreneurs and small businesses, visit fixedfeelawfirm.com. And thanks for listening. Be sure to like, subscribe, and leave a review if you found this episode helpful. Thanks, Darryl.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.